I know I really don't need this, but we have people in Zoom land that'll be zooming in. So if we don't have the mic, the people in Zoom won't be able to hear us. So a few people from, we actually have somebody from Arkansas coming in. So anyway, thanks for coming. The title of this is, well, the Planning Playbook, Planning Ahead with a Purpose. And we're going to talk about estate planning. Is the basic things that you can do for planning your estate. So with that, we'll just hop right to it, and Max is going to start us off.
Yeah. So first, we'll talk about why is an estate plan important. I mean, I think we're all familiar with somewhat of what an estate is, but really why is it important? Well, it's kind of the game plan as far as the distribution of assets upon our death, and just planning ahead for exactly how we want things to happen, not only after our death, but if something were to happen to you in your lifetime where you can't make your own decisions. So just making sure that you're in control of how things are going to operate or happen in the event of something happened to you, or of course, in the event of your death, and ensuring assets are going to be distributed according to your wishes, managing loved ones' financial future. So just making sure a spouse or kids are going to be set up as you would properly want. There's a lot of documents and things we'll be talking about today that'll really establish how these things will be put in place. The other thing too with loved ones, I mean, you think of like somebody like me, or you've got young kids. If your kids are still minors whenever you pass away, what's going to happen to them? Where are they going to live? Where are they going to go to school? Even if you have adult children, maybe adult children with special needs, what's going to happen to them upon your death? So just all things to consider, that having a plan rather than letting the courts or the state decide what's going to happen, you're going to be in control. Legal and tax issues. This is a really a big one to help reduce legal and tax issues. And we'll touch a little bit more on the tax issues later. A lot of that can be more equated to higher net worth people, but really, especially the legality side, having a plan in place will help reduce some of the burdens there. And then covering all contingencies. So that would just really come in line of, if something were to happen to you in capacity, what's going to happen to how all of your assets and things are handled, who is going to handle that for you, whether it be both the power of attorney side and then the healthcare side as well too. So what is an estate? I think a common misconception people have is that, well, I don't have an estate, or I don't need a really estate plan because I don't have much of an estate, or I don't really have much to give or to leave behind. Well, the fact of the matter is we all have an estate. We all have something to leave behind, whether it be a few $100s or millions of dollars. We all have something that is in our possession that we are going to leave behind to the next generation or beneficiaries. So really, in its simplistic form, an estate is just all of your assets. So think of all your real and personal property that is going to be owned by you at the time of your death. And debts are a part of that too. So just think of it kind of as almost like a balance sheet, just listing out what are all your assets, what are my liabilities, and that is officially your estate. And so often too, we think of an estate or this whole estate planning process on the financial side, but so much of this comes into the non-financial side too. We talk about those knick-knacky things or those family heirlooms that come into play, and that a lot of times it's really what those are the ones that cause issues amongst families more often, it seems like, than the financial side. So planning ahead for those things and being able to know what is all there, what's all under your estate umbrella. So what are the parts of an estate plan? We'll hit on all of these. The main parts are going to be a will, a trust, the estate inventory, power of attorneys, and then beneficiaries. So we'll go into all those in detail. So first, talking about the power of attorney, there's really two main types of power of attorney: a durable power of attorney and a healthcare power of attorney. The durable power of attorney is going to be the POA that most of us, I think, probably think of when you think of a power of attorney. This is going to be somebody who steps in place for you if something were to happen to you in the event of incapacity. So something happens to you, an accident, and you no longer can make decisions for yourself. This is going to be that person that you name that's going to step in and act on your behalf. So conduct business for you, be on your investment accounts, bank accounts, handle transactions, pay bills, things like that. Somebody who's going to take over that responsibility. The durable power of attorney is revocable. That is something that you can change at any time. Of course, you want that to be somebody who's going to be very trustworthy. More often than not, this is probably going to be a spouse, but it doesn't have to be. Sometimes spouses, maybe they want to name an adult child or a friend who is close by who can handle things. Or if you're not married or a spouse is deceased, thinking of who that trusted person is going to be. I use the term durable power of attorney. That's the most common one. And what that means is that when you sign this document that states who your power of attorney is, immediately upon your incapacity, the durable power of attorney steps into place and is there to act on your behalf. There is a non-durable power of attorney, or sometimes called a springing power of attorney. And what that means is that typically you have two doctors that sign off that you are incapacitated, or you're no longer able to make decisions on your own. And then the springing, hence the springing term, that's when that power of attorney will step into place. The other important one is the healthcare power of attorney. So kind of as it would apply, this is going to be the person who steps in and makes healthcare decisions for you. So nothing to do with the financial side. It's just strictly those healthcare decisions that you would want them to act. And now there's documents that we'll talk about later that is going to list out what you want to happen and how you want things to happen if in the event that something were to happen to you. But that healthcare power of attorney is going to be the one to enact that and make those that communication with the doctors and the medical staff and make sure. I think in both circumstances, it's really important to a lot of times inform your power of attorney or healthcare power of attorney who they are and what their roles are, and talk about what your wishes are. Everything is going to be lined up and stated in your will and potentially in your trust document. But just to have those conversations at a time, so when push comes to shove and something happens, they are fully equipped in knowing what's going to go on. And I mean, there's a lot of cases where somebody has no idea they're named as a power of attorney or healthcare power of attorney, and then they're kind of frazzled and you're thrown into it, and that can be really overwhelming. So just always having those conversations is always helpful. Something I think is important too to talk about is not only is this, I think, necessary for those of us who maybe are married or have kids, but those of us, I mean, and some of you who have kids or potentially grandkids that are single, I think especially adult children who are not married, having those things listed out. And in the event that something were to happen to them and, mom or dad or whoever goes to the hospital, well, nobody can make decisions for them until the courts get involved or until there is a document in place that states this is the person who's supposed to act for me at this point. Now, even if you weren't to have a healthcare power of attorney, most hospitals, more often than not, I think will speak to the spouse. But sometimes if there's a dispute and things like that, they will say, hey, we're not going to do anything until we get a court order saying who we talk to make these decisions. So rather than having the courts decide, it's better to just plan ahead. It's a simple thing. Just get it in place and decide that yourself. So the other thing I'll mention too is that for both of these, it's probably really important to have a backup power of attorney or healthcare power of attorney. I'm called an agent. So not only do you want to name somebody to be that person, but if something were to happen to them, who is going to step in their place? And very important too, if something happens to your power of attorney and then you just never change a document, and it goes by and you don't think about it again. So a very important document that I would strongly encourage everybody to have, and this is something important for everybody, not just if you're worth $1 billion or a few $100s. Like I said at the beginning, we all have something to leave behind, and we all have wishes, whether it be in our incapacity or at our death, how we want things to be handled. So how will that all be handled? A lot of that's going to come here in the will. So we've heard a lot about a will, I'm sure. In its simplistic form, really what a will is, it's a guide to your final wishes and how things are going to be laid out in the event of your death. And it's going to list all of your kind of non-contract driven investments and accounts and personal belongings, and state who those are going to be going to and in kind of what fashion. So this document really helps. It simplifies things for the beneficiaries and for the loved ones who the descendant is leaving behind. It makes things so much simpler. I think in an event that a loved one is gone, there's a lot of grieving going on. There's a lot of emotions, of course, and so having a will and a trust later that Tim will talk about these are things that just help simplify the process. It helps with disputes, there's no guessing and stuff like that. It's all going to be laid out there exactly how the descendant writ out and wishes. So Tim will talk about this in a little bit too, but the will is important for all non-contract accounts. So when I say contract accounts, this is going to be like a 401k, an IRA, life insurance. These are all things that have listed beneficiaries on them. So no matter what your will says, those beneficiaries will take over those accounts upon your death. So you could have, I want my oldest son to inherit my IRA, but if your IRA says my oldest daughter's going to inherit, it does not matter what your will says. The contract's always trump the will. So for the will, we want to name everything that is outside of a contract account should be in the will and should list where things are going to go. Again, we talked about or made the comment about grandma's pie plate, but this is important too in the will of having those certain family heirlooms and my mom's mom, in case my grandma talked with all their jewelry, like who's going to get this ring, who's going to get this necklace, things like that, if it's important to you and important to the next generation, it's good to have those things listed out in the will. Also in the will, you'll name an executor and also an alternative or successor. And this is going to be the person who's basically going to read the will document and make sure that the things are going to go exactly how the will states. So distribute those assets to beneficiaries, keep beneficiaries informed of how that whole process is going to work. So the will is a very important document. Another really important point to make of a will is that is actually a public document. So with a will, you will go through the probate process, and we'll talk about that term in a little bit, but you'll go through the probate process, and the will gets submitted with the courts, and technically speaking, anybody can go and see what is in a will. Most people probably are not going to care, truth be told. Most wills, especially for married people, are kind of the simple "I love you" wills. My wife gets all my stuff. If my wife predeceases me, I get all hers. If not, it goes to the kids. That's probably how most are listed, but where a lot kind of come into play, where maybe some people are nosy, is think of a single bachelor with farm ground or somebody who was never married, no kids, and where their assets going to go. Sometimes people get curious about that, but a will is a public document. When Tim gets to it, a trust is not. A trust is private, but you go to the courthouse and ask to see the filing. So I don't know if there's anywhere else you can go online, but yep. Yeah, so if you have a trust established, you'll still have a will, but it'll be a pour-over will, like you talk about. So a pour-over will is really important, the trust document. And Tim will talk about this.
Yeah. So one of the big things
this
is your estate.
This one's me. Yeah.
Okay.
So when it comes to the will and kind of this estate planning process, I mentioned the first thing that you really want to do when you're kind of thinking about this is establishing your estate inventory. So just listing out, what do I all own? What are all my assets? What are my debts? And having that all listed out. I think a really good place to do this is just have a spreadsheet or files in place where you start kind of considering what I do have. The bottom point I think is important too, that personal items of family heirlooms, collectibles, etc. Grandma's yellow pie plate, where do you want those things to go upon your death? And how is that all going to be handled? So and a lot of that the will and potentially the trust can take care of. So
when it gets right down to it with the personal things, we actually call it a side letter. You're not going to go through and list everything that you own in the will. You don't go say that I have a 12-gauge shotgun that goes to this kid and this. That's done with what we call a side letter. So the will mainly just says, here are my beneficiaries. They get all the assets. And then, but a lot of people, the issues when settling an estate are not with the financials. The financials are there. Everybody understands if both parents are gone and there's 4 kids, it gets divided 4 ways. It's, as Max kept, was talking about the family heirlooms, it's the jewelry, it's the guns, it's the grandma's yellow pie plate. Sometimes nobody ever talks about those things. And then when our grandparents or our parents pass away, those are the things that cause the biggest problems. Somebody said, well, I wanted that. That yellow pie plate was special to me, or that china, or that dresser, that bedroom set, whatever it is. Those are the things that have caused problems with a lot of the estates. So um, there's ways that people can get around that. So the side letter would be one thing. So just a list of things, and it has a list of things that may be of value, that maybe somebody said, hey, grandma, can I have that? And she puts it in that little side letter thing. So I've seen people will go through and they'll take a piece of tape and put it on the name on the, put their name on the back of something, like a plate or something that sits in the china cabinet or something. And they'll say, okay, that goes to Tim, that goes to Chris, that goes to Todd, so on and so forth. So that's the way they get a lot of it divided up. I've seen places in my mother's family did that when my grandparents died. They actually had a family auction. And I'm supposed a lot of you have been through all of this before and have seen it happen. But in her family, my grandparents lived on a farm, and they had a lot of antique furniture. And so my mother and her two brothers and sister, they actually had this draft lottery drawing type of thing. So they drew numbers. Somebody got to go first, somebody got to go second, third, and fourth. And they actually, if you drew first, then you got to go and pick whatever you wanted in the house. Whoever was the second got to pick the second thing. Whoever was the third got to pick the third. The fourth got to pick the fourth and the fifth. So it went 1, 2, 3, 4, 4, 3, 2, 1, just like you're doing a draft. And they went through until everybody had everything that they wanted in the house. And then after that, we hired an auctioneer, professional auctioneer, invited the public to come in, and they auctioned off the rest of Grandpa and Grandma's stuff. My other grandmother, when she passed away, they actually had a private auction, a silent auction, where all her kids would go through and say, okay, I'm going to go put $1,000 on this bedroom set. And one of their siblings could go and outbid them if they wanted and put $1,100 or something on there. In the end, they still got some of that cash back, but they actually had to write a check for those family furniture pieces and heirlooms that they were bidding on. So they did it with an auction. It added money to the estate, and then the kids divided all that money up a little bit later. But in the end, there's not a right or wrong way. Just have some sort of a formal thing to go through that kind of divides up these heirlooms if they're not already spoken for. Because again, we always say the finances are the easy thing, because those usually have beneficiaries on there. It's those personal possessions. So guns, jewelry, china, you can think of it. So anyway. So anyway, a lot of different types of accounts, especially when we're talking about IRAs, 401ks, 403bs, all have a beneficiary listed. So we talk about assets with a named beneficiary. These are generally financial assets that the beneficiary is named. The nice thing about an asset where the beneficiary is named, that skips the probate process. I'll say it again. Assets where beneficiaries are named skip the probate process. If a child is named as a beneficiary when their parent passes away, as soon as they have a death certificate, a certified death certificate from the state, they can come in and they can claim that asset. It does not have to wait, does not have to go through anything of the probate process. So the probate process, the court has to get involved. The will has to be validated, the executor has to be named, and there's a formal appointment paper that does all of that. So, yeah. Yes.
Five letter, that's the beneficiary, and that would avoid probate.
That is correct. Yeah, that does not have to go, because that does not have to necessarily be probated at that time. So, correct. But that's just really, really important to do that. So anyway, the bullet point here, don't forget about everyday assets like your checking and savings account, as well as any brokerage and other investments. So if you don't have any beneficiaries named on those, which is okay, it just reverts either to what the will says, or if you have a trust, reverts to what the trust says. But you can name a beneficiary on a checking account or on a savings account, or you can even go so far as name a child as a joint owner. I don't know that I necessarily recommend that unless you just have one child, it's an only child, then you can do that. But most of the time there, I would like a savings account or a CD, you can certainly name children as beneficiaries on there. The other thing too is you can just create a list of all your accounts and passwords where they all are. Just back to Max's point, just a slide, go take an inventory and make sure that everybody knows where everything is. I had a client a few years ago, maybe about 15 years ago. He was in my office. He says, "Yeah, I got $90,000 of silver buried on my farm." And I'm like, "How many people know about this?" He goes, "You." And so he ended up telling me where his silver was buried on his farm. It's, well, it's in this machine shed over on this side of the farm, and it's in the southwest corner there. You see this big oil drum. You push that oil drum back, dig down a little bit, you'll find all the silver. I'm like, I think you should tell somebody else. I don't really want this responsibility of knowing where your $90,000 of silver is. And that was 15 years ago. It's probably worth 4 times that amount now. So anyway, this client, he's still a client. He actually did tell somebody else, told his son where it was, then he moved it. Well, I'm glad he did. I didn't want that burden on me. So, but so he did move it. But yeah, take an inventory. And if you're going to hide stuff like that, tell somebody, for crying out loud. It's just don't take a chance that it's not going to show up. But anyway, back to your other bank accounts and things like that. If you have pins, just have an inventory. I have a lot of clients that have just said, "Hey, if something happens to me, just go see Heisterkamp. He'll take care of it. He knows where everything is." And I'm like, well, I don't know if I know where everything is. At least the financial accounts I do. So, anyway.
Yeah, I think that's really important too. Is, you know, if you have a spreadsheet or a list of all your accounts and logins and stuff, have your financial advisor, your financial planner on there, have your CPA's name and information, your attorney. And those are going to be kind of the first calls that you or a loved one is going to be making in the event of death of some person. So
some people
really
have these files and these 3-week binders. I'll actually take our business card and tape it there, so the kids will see it there.
Yeah.
But,
and I just think too anymore, now that we all have accounts online, we all have logins to whether it be investment accounts or bank accounts or even social media accounts. It's good to have those logins somewhere for somebody to have access to in the event that something were to happen to you. So,
or at the very least, just have a statement so they can call the benefit or the custodian with that. Go ahead. Revocable living trust. We'll talk a little bit about trusts here, because a lot of people decide, well, should I have a will or should I have a trust? It kind of depends, but we do like the trust, and we'll talk about why. But first of all, the trust has 3 major parts. There's a grantor. The grantor is the person who has established the trust, the person who owns all the assets. And they say, like for me, Tim Heisterkamp, I got all these assets. I am going to set up a trust, and I'm going to retitle all my assets into the trust. That person is called the grantor, puts all the assets in. That person also probably serves as a trustee. Now, it wouldn't have to necessarily be that way. I could set up a trust and then look at one of my kids and say, I want you to be the trustee of my trust. But that doesn't happen very often right off the bat. Usually when the person sets up a trust, they are competent and capable, and they serve as trustee of the trust and just continue on with their own business as if it was just in their own name. Finally, there's the beneficiary. So while I set up a trust and all these assets are mine, and technically it's for my benefit. But in the end, when I die and my wife, Chris, dies, then the trust will establish my kids as the beneficiaries. And then the trust, instead of the will, is the document that we look to that distributes our assets. Now, not those assets that we said by contract. These are the house, the car, if we had guns, precious metals, jewelry, china, furniture, all that stuff, it will go out that way. So I'm good there. Go ahead. So like we said, the trust will take place of your will. Acts very much like a will. It makes for a smooth transition. The trust helps you avoid the probate process. So if you really want to get down the weeds, the probate process is that you actually have to have the court validate a will. The court does not validate a trust. The court will say, yep, this will says this is an executor, and then they do what we call a letter of appointment, and then that sets the probate process in motion. With a trust, you don't have to go through that. The trust is there. The trustee has a fiduciary responsibility to carry out your wishes. So when a person dies, let's say I have my trust, and I'm the trustee and I die, I will have named a successor trustee. What happens when I kick the bucket, or if I even became incapacitated, had a stroke, had Alzheimer's, and was not able to carry out my wishes? In the trust, you will name a successor trustee. And that successor trustee has a fiduciary responsibility to step up and make sure that everything that I've said in the trust continues to go on. But anyway, in the end, when I die, it does make death or incapacitation, because it does avoid the probate process. Distributing the assets of the trust is much like a will. It's just quicker because we don't have all this huge waiting time that we have to wait through like you do have a will. Probably one of the biggest things about a trust over a will, and Max talked about this just a few minutes ago, is that the trust is private. The will is not. The will get filed at the courthouse, and anybody who wants to go read it, they can. So most trusts will have a pour over will. And all the pour over will really basically does two things. Number one, it says when, for an example, Tim and Chris Heisterkamp die, if there's an asset that we forgot to put in the trust, it will let the accessor trustee retitle that and put it into the trust. So that's the first part. There's a second part of that trust too. So the pour over will, then it just turns around and says there is a trust. There's nothing to see here. It's just like,
Yep.
You know, it just says, yeah, Tim and Chris Heisterkamp, for an example, had a trust. If they both die, refer to the trust, and then it would just have people just move on. So there's just really nothing to see there.
The main components is going to be speed, privacy, and then cost, potentially cost savings.
Cost savings. So technically speaking, an attorney can charge 2%. Go ahead and go to the next one too. The attorney can charge 2% to probate a will. But the trust, we kind of cut the attorney out at that point. So initially, when you set up the trust is more expensive. Right around here, it's usually right around $4,000 to set up a trust, or a will maybe a few $100s. But then when you probate a will, if the attorney charges 2%, you could be paying $20,000, $30,000, $40,000, depending on how big your estate is, where to do the trust at the end, there's not going to be a whole lot of attorney fees. You'll need the attorney for a few things. If like you had a house and real estate, has to go through the title opinion and property transfers and things like that. But in the end, the trust is more expensive to set up, but saves you money in the long run. Now around here, the attorneys, for the most part, I don't believe the attorneys are charging 2% anymore. So if you had $1 million estate and they charge 2%, it costs $20,000 to probate your estate. I don't know that a lot of the attorneys are still doing that. They can, but I don't know that they are. So a lot of them will just do an hourly rate at that point. So when you establish a trust, you create the trust and name the trustees and the beneficiaries. Transfer the assets. It's when we say transfer the assets, I think it kind of makes it allude something else. All you're doing is retitling the asset. So Chris and I have a joint checking account. That Tim and Chris Heisterkamp joint checking account just gets retitled to the Tim and Chris Heisterkamp revocable trust checking account. It just gets re-registered. A lot of times account number won't even change. So when we talk about transfer of ownership, we're really talking about changing the title. That would change. And the key is, if you have a trust, you want to put all your assets in there that's not driven by a contract. Your house, your cars, everything that needs to be retitled, you want to put in there. Now, we don't put IRAs inside of a trust because the IRA is driven by the contract. You have the owner and you have a named beneficiary. So there's no need to put an IRA in the trust. Life insurance, no need to put life insurance inside of a trust. Now, there are special trusts for life insurance, but for most part, if you don't have any huge estate tax problems, and you just leave the life insurance outside. Same with annuities, don't have to be inside of a trust as well. If you've set up accounts that have beneficiaries, so if I wanted to say, I want this account to go to this grandchild, that doesn't need to be in the trust either. So you could spell it out in the trust, but you can set up that account, name the beneficiary, and you're done with that as well. So during your lifetime, yes.
Wasn't there so let's say you have 3 income checks a year. Would you put that Would you put that in an account to transfer on debt? Or would you put that in an account that's owned by the trust?
One or the other. There's not a wrong way. So if you had a trust, I would probably put it in the trust. But if you didn't have one, then you wanted to do it as a TOD, transfer on debt, you can certainly, there's not really a wrong way to do that. So if you, in the trust, so let's go back to this example I just used. So I'm going to keep using Tim and Chris Heistrom. We have 3 kids, Aaron, Andrew, and Philip. So when Chris and I are gone, we want all of our assets to go to them. But let's pretend that I wanted to take an asset and I wanted to give it to Troy over here. You know, Troy has done a lot for me. I just want to do something special for him. So I might set up an account where I'm the owner and then I might name him as the beneficiary. So remember that account that I would set up with the bank is driven by the contract. And you're going to see it in a little bit, but Max said it a little while ago, contracts always trump the will. Contracts will always trump the trust. So when you have a contract, that contract is legally binding and it cannot be overridden or overruled by what you say in your will or your trust.
What's the difference then between a account with the beneficiary, which is a check account, or a COD?
Same thing. It's synonymous.
Payable on death, oftentimes for checking accounts or bank accounts. Transfer on death, a lot, that's more like how our investment accounts, non-qualified or non-retirement investment accounts will title them. But it seems like accounts will call them PODs. Maybe some do TODs. I don't know.
Yeah. TODs, it kind of depends on the state and how the state law is written. Some states say the word TOD and some states say POD, transfer on death and payable on death.
But preferred avenue of transferring funds to the next beneficiary. Being a joint holder with the trustee or the. No.
Being a joint owner, you're saying?
Correct.
Oh, if
There's 2 owners or 2 grantors,
My mom has a trust. She's either gonna transfer that, or have it not be in the trust.
Yep.
Or then be a joint with her. So joint with her, that's the plan, right? Because that would be liable for which trust.
well,
I don't think it would make you
no,
liable
not,
for
no,
things that,
not in that situation, but so you can have a joint TOD, for an example, and you can have a joint trust and it only gets executed to the next generation when it's a second to die type of thing. So Chris and I, we have our checking account, joint tenants with rights for survivorship. If she dies first, I become the sole owner. Once I die, then it goes through the probate process. If we have it in a revocable trust, Tim and Chris Heisterkamp revocable trust, she dies, her name's basically, well, I actually wouldn't have to remove the name, that trust stays there, but then it doesn't get distributed till after I die.
yeah, but even if you have a joint account, say with your mom, that's not, it's just a joint account with you and your mom. If she passed away, then that becomes 100% yours. So that's, outside of the trust, no, doesn't matter what,
Even if there's other beneficiaries.
even if there's other beneficiaries, yeah.
Owners first, beneficiaries second.
Yep, a joint tenants with rights of survivorship, you'd become.
So anyway, in a nutshell, the trustee, the parts of the trustee, be it yourself, you take care of all your business while you're able to. If you become incapacitated, your successor trustee, and then upon death, your successor trustee takes over and then distributes the assets according to your wishes that are listed in the trust. So
They're pretty good there on trusts.
feel free to ask any other questions if you want, or when we get to a later slide, if you want to come back to this, you can.
Is it possible to fit an IRA that's not distributed trust? Death dynasty trust or something like that? Is that a possibility?
No, you have to, whatever the trust says that you have to do there. So there are some things called generational skipping trusts. So like grandpa and grandma say, you know what, kids aren't getting anything, as stuff is going down to the grandchildren. So were a popular thing way back when, but I think they might have been more of an estate tax thing. So, but no, the trustee has a fiduciary responsibility to carry out the wishes of the grantor.
But of course, there can be provisions in the trust that the grantor says, this asset is not going to be distributed for X amount of years, or this thing can't be sold, this piece of farm ground can't be sold for X amount of years. So that those are all provisions that could be included in a trust. Once,
Mhm.
and at that point, it would become irrevocable. You know, if once it's revocable during your lifetime, but when both trustees are gone or both grantors are gone, it becomes irrevocable, and then everything it cannot be changed. It's all binding at that point.
Yeah, and we've seen people do that. I've seen people dead for 50 years still controlling the farmland from the grave. It's wild why they set that up. But, 50 years ago, there might have been a reason for it. Right now, I don't think there's much of a reason to try to control it that far, unless you have a child who's a spendthrift and you're afraid that they're going to blow through 1,000 acres in 2 years on toys and vacations and living wildly. But those are spendthrifts, are the reason why you'd want to control it for years and years and years after you're deceased. Or maybe you have a special needs child. I think Max may mention that earlier. If you have a special needs child, you can set up a trust that would help provide some of their care for the rest of their life. So,
yeah. Talking next about incapacity, the planning involved and the documents kind of that go with that. So thinking about an incapacity plan. So what do you want to happen to you, or who do you want to kind of step in and control things or help you in the event that you no longer can make decisions for yourself? So obviously, if we have that healthcare and general power of attorney listed, things will be sound. But if you don't have those power of attorney designations or that person listed, the courts can actually get involved and assign a guardianship or a conservatorship. And those are probably things not a lot of us want. They're not only very costly, can take a lot of time, but more often than not too, that they might name somebody that you would not want conducting business for you, whether it be on the financial side or the healthcare side. So just a really important thing to have established. Like I talked about earlier, having a plan written out and having a conversation with that particular person of how you would like things to go on in the event that you were no longer able to make decisions yourself. So what did that person do? Of course, oversee healthcare, as we talked about. Understand insurance disability benefits. So that's going to be a big thing, especially for people who are still working, have short-term or long-term disability benefits available to them, making sure that they're getting enrolled or getting those disability benefits going if there's anything available there. Of course, notify bank accounts and other financial intermediaries. So letting them know that, hey, so-and-so is incapacitated. Here's a legal document stating that I have the authority to conduct business on their behalf, or of course, in the healthcare space, make decisions for them when the time comes. Transact necessary business to pay bills, keep up as they would wish. Advanced healthcare directive and living will. Sometimes these can be even the same documents, but in any case, they're very, very similar. So a legal document that's going to offer guidance on those medical decisions, healthcare services in the event that you are incapacitated. So again, this is only in the case that something happens to you where you are legally defined as incapacitated, can no longer make decisions for yourself. So that's where this would all come into play. Again, appointing an individual to make those decisions for you. So thinking about, well, what are some of those decisions that you would need to make when you think about the sustaining and then end of life? So I kind of listed out some when you think about life sustaining services. So CPR, ventilation, feeding tube dialysis. What's your feeling or opinions on those, and having that stated out in one of these documents? And then the end of life. So comfort care. Are you just wanting more pain management? Do you want to kind of throw the kitchen sink to really try to turn a corner with whatever's going on? So having that listed. Would you prefer to be at home? Are you okay with being at the hospital? How you want things conducted there? Organ donor. That's another big one too, is what you'll have listed in there as well too. So very important documents to have. Again, having those conversations ahead of time can often make things a bit easier too. It's just, these are really stressful, emotional times. Of course, if something were to happen to you for your loved ones, and so having everything written in place just really helps ease the anxiety and at least lets them focus on just being with their loved ones and not having to make those decisions. Because whether it's happened in your life, or we can at least ponder that what would happen if, say, a spouse or a kid has to make the decision on like a do not resuscitate. Other siblings or other people in the family might have an opinion that does not line up with what that particular person does. So if you don't have these things in place, it can put a lot of burden on somebody else and have to make a really hard decision that other people in the family might not agree with. And And those are things that can have a lasting impact for a lifetime with families. So
My father, when he passed away, he was in the hospital, and when he was in the hospital, he coded, and they started to do CPR on him, and they were working on him for a long, long time. Nobody knew what was going on, but my brother was actually in transit to the hospital, as was my mother and my sisters. And my brother got to him first, and the doctor's immediately came in and says, "Can we stop? Can we stop?" They just said that we don't think there's any hope of bringing it back. Can we stop? And my brother said, "I am not making that decision." So my mother got there shortly after that, and then she was the one that made that final decision. But yeah, if we didn't have that, Dad did not have that. He was only 61 when he passed away, so he just did not have that in place. But he had it. If he had it in place, then they wouldn't have to put that pressure on my brother or even on my mother, to tell you the truth.
Yeah. Even if you know it's the right thing to do, it still can be heavy. It's very, very difficult decision. So what happens after you pass? Talking about probate, intestate, and executor. So really there's kind of three things. Well, first we'll look, I mean, if you have a trust, that makes things really simple. You can kind of even avoid this whole probate process like Tim was talking about, assuming everything is in the trust that it needs to be. But say you don't have a trust, then we're looking at a will. So you'll start the probate process. We'll submit a valid will, the executor will, and then that'll get this process started. So the probate process is just the legal process to distribute assets of an estate. And a large part of that, the will, assuming you have one, will dictate kind of exactly how everything is going to go, and why that's really important to have. So during this whole process too, it's going to be changing the titling from the descendants to the new heirs or the new beneficiaries of the accounts. Supervise the distribution of assets. So this is where your executor is going to be in play and make sure things are happening in orderly fashion. And the creditors also will have a chance to, if there's any outstanding debts that are owed, is it 3 to 6 months or 3 months after filing of an estate, 4 months, where they can kind of come and lay a claim to the estate as well too. So the probate process can be sometimes lengthy depending on the size of the estate, the complexity of estate, especially if there are creditors involved as well too. So having a will, having documents in place too, can just really speed this up and make it somewhat easy. Dying intestate. So this is the definition of somebody who dies without a will, without a valid will. Dying intestate is the term. So yeah, legal process. If somebody passes away without a valid will, other legally binding documents to distribute or dictate how assets are properly distributed. So in the event that you die intestate, well, guess what? The state is going to end up deciding where your accounts or where your assets will be distributed upon your death. Now, it really is, they follow an order of operations, and more often than not, it's probably going to go to somebody that you would want it to anyway. So if you're married, the way the court looks at it through the order of operations, do you have a spouse? Yes, spouse gets everything down the line, through this whole process. If you're not married or widowed, do you have kids? Yes, well then the assets get distributed typically evenly amongst the kids. No kids or spouse, then it goes to parents. If no parents are alive, then it would look to siblings, and if no siblings, then yeah. And then is it grandchildren or nieces or nephews? Yeah. Grandchildren, then siblings.
Shouldn't just assume if there's no kids that there is now grandchildren.
Yeah.
So we've had clients where they outlived both their children. I can remember specifically.
Yeah. So that's kind of the order of operations, but at the end of the day, it's why let the courts decide or somebody else dictate what's going to happen to your assets and your belongings in the event that you're no longer here. So just being able to have all those documents, the plan set in place to make sure that things are going to happen in an orderly fashion, a lot quicker and the way that you want to. So duties of an executor. So again, the executor is going to be that person that is listed in the will of who's going to be handling the estate upon your passing. And so again, somebody that you trust, somebody that can follow orders and make sure things are going to be done in a timely fashion. So somebody that you A lot of times it's going to be a spouse, maybe not, maybe a child, but somebody again that you trust. So here are kind of the duties of an executor, and maybe some of you have been an executor before. It is somewhat of a big responsibility, especially, you know, if you're the executor and you've got siblings that are kind of asking, hey, where are things at all the time? I mean, that can be somewhat of a burden as well too. But a lot of responsibility, kind of a lot that goes on. And I always think too, as an executor, lean on the trusted contacts, your trusted advisors, you know, whether it be financial advisors, CPAs, attorneys, family members who you can go to as well too. That really helps. So got to contact the attorney, file the will, initiate the probate process, keep the beneficiaries informed. That's a really important one as well too. And they'll do this with the attorney, but inventory of assets, determine the current values, because I don't think either one of us has mentioned it, but in a lot of assets will get what's called a stepped up cost basis at the time of death. So any, you know, non-retirement investment accounts, any like farmland, houses, things like that will get a stepped up date of death value. So say you bought a stock at $100 20 years ago, and now that stock's worth $500. Upon your passing, your descendants or heirs will inherit the stock at $500 per share. So it's important to have a list of those things, and the attorney and will make sure that you get a fair value of things at the date of death. Sometimes there's some partial distributions that happen before the full final. Sometimes people say, no, they'll just wait till we get everything established and they'll do kind of one final payment to all the beneficiaries. That always kind of depends on the circumstances, but yeah, a lot of duties for an executor, a lot of responsibility, but hopefully if you have things set in place and the documents in place and people to rely on, it can make things a lot easier.
A lot of transfer of property, gift, will, trust, contract. So we'll talk a little bit about some special ways that you can transfer property while you're still alive. So first of all, we talk about the federal estate tax. I'm going to talk a little bit about this year, but next year, the numbers that we have up there is the federal estate tax only applies if you are own more than $15 million of assets. As a married couple, you each get the 15 million, so you can have $30 million of assets, and you will not pay an estate tax until the first dollar over $30 million. Okay, that number when I started this career 28 years ago was 650,000. You had to start paying estate tax of 650,000. Since then, the politicians, as they become richer, I'll tell you how it really is. As they become richer, they've increased that number because they all have estates that they want to avoid estate tax on it as well. So one of the important things to mention is that the estate tax is the same as a gift tax. It's an estate tax when you die. It's a gift tax if you try to give it away when you're alive. So this happened years ago. People said, well, there's an estate tax. And they go, well, I know what I'll do. Right before I die, I'm going to give all my assets away so my estate doesn't have to pay that estate tax. Well, the government wised up to it and they said, well, we're going to call it a gift tax then. So if you give 15 million away, you're going to have to pay a gift tax if you do it while you're alive. So anyway, this is for 2026 and 2025. If you wanted to know, it's 13,990,000 this year per person. And and then one thing about this is that a husband and wife has that. If you're married, you each have $15 million next year. So let's say one person dies early. We want the surviving spouse to file an estate tax return. Let's say that you're only worth together $5 million. Why would you file an estate tax return if you're not worth 30 million? So the reason why we do that is so that the surviving spouse can claim the deceased spouse's 15 million. What if the surviving spouse a few years later went and bought a lottery ticket and won a multi-millions of dollars? And all of a sudden they went from, being a relatively small estate to maybe they were worth hundreds of millions of dollars. So by having the surviving spouse file an estate tax return for the deceased spouse, they get to claim the deceased spouse's 15 million. And then they have the 15 million themselves. So now they can have a 30 million, the surviving spouse can have a $30 million estate that is not subject to federal estate tax. Okay. So you would, the surviving spouse will have the attorney or your tax person file a federal estate tax return. Now, if you're not worth 15 million, there's no estate tax that's due, but you still want to file the return to get it on the record that we filed the return, there's no estate tax, and then the surviving spouse is going to take on that extra 15 million. Okay. Most attorneys around here are good and they will do it. They will go ahead and file the estate tax return, even though you don't have an estate tax problem for that very reason. What if you win the lottery? What if you have a really good financial advisor that makes you millions of dollars? Okay. So there's all sorts of things that could happen. You never know what happens, you know. I mean, we've watched like gold go through the roof these last couple of years. What if somebody had a lot of gold and didn't think much of it? Now all of a sudden it's worth, you know, tens of thousands of dollars an ounce. You know, there's farmland. You could have farmland and all of a sudden farmland goes through the roof. There's all sorts of reasons why you could end up with $30 million or more. But, so we just don't want to leave that on the table. So no estate tax is going to be due until you're at least a married couple filing jointly 30 million. If you're an individual, it's 15 million. No estate tax is due. But we just want to make sure that we claim that. As of January 1st in 2025, there is no longer any Iowa inheritance tax. So there's a federal estate tax. There used to be an Iowa inheritance tax. Iowa did away with its inheritance taxes this year. So no matter what.
And by the way, if anybody was curious what the federal state taxes are, if you're somebody, single person over 15, married couple over 30, it's 40% tax on that, over that dollar amount. So
every dollar over 30 million, if you're married, it's 40%.
Yeah.
So if you're 30 million and $1, that $1, you're going to pay 40 cents on that.
now the very, very wealthy they set up really complex trusts and things to try to get away from a lot of that as much as possible. But at the end of the day, there's a lot of dollars that are going to be taxed at 40%. An example I used to give a lot was the Chicago Bears are owned by the McCaskey family, and a lot of their assets, in fact, the majority of their assets were tied up in the Chicago Bears organization. So the rumor always was, and it still actually could happen, when Virginia, the surviving descendant of the McCaskey family, passed away, they were going to be forced to sell the Chicago Bears or her descendants because all of their money was tied up in the Bears. And even to pay the estate tax of 40% over, the Bears are probably worth $7 billion or something, they'd be forced to sell. So she actually passed away here like 6 months ago, and they're probably still going through that whole process. So we'll yet to be seen what might happen there. But it can cause issues as far as the very, very wealthy having kind of be forced to sell things just to come up with the tax in non-liquid assets.
So let's talk about gifts then, how to transfer property gifts. So every year, this year, any person can give another person $19,000 without incurring any gift tax. Next year, it goes up to $20,000. So I can give everybody in here this year $19,000 and no gift tax would ever be due. Okay. A married couple has that times two. So I can give $19,000 to my daughter, Erin. Chris could give $19,000 to my daughter, Erin. We could each give $19,000 to her husband, Mark. And so, I mean, we can give a lot of money away. It's not going to happen, but we could. Next year, that number goes up to $20,000. But the question is what happens if you give a child or any one person more than $19,000 this year or $20,000 next year? Well, then you're required to file a gift tax return. Now, remember what I said earlier. Is any gift tax due if you gave more than that $19,000? The answer is no. Remember what I told you a little bit ago. Nobody has to pay an estate tax or a gift tax until you've given more than 15 million away. Okay, so what happens here, if I gave, let's say next year I gave somebody $21,000. So the $20,000 is free and clear. There's an exclusion. There's nothing that counts against me. But that extra $1,000, I have to go to my 15 million. I subtract $1,000. Now I could only give 14,999,000 away. Okay. So what you're doing is if you give more than that 20,000, you're just using up what we call your exclusion, your $15 million exclusion. or a married couple, you're $30 million exclusion. So, and it's not until you've given that much money away do you actually have to pay a gift tax or pay an estate tax. Does that make sense? Somewhat complicated to grasp, but that's actually the way it works. So some things that are skipped from your annual exclusion, you can give your spouse as much money as you want without having it count as a gift. If you pay somebody's tuition and that tuition was like $40,000, that does not count as a gift. If you pay somebody's medical bill and that medical bill was $50,000, that does not count as that $20,000 gift. So tuition and medical bills, if you pay it directly to the school and directly to the hospital or the doctor, that does not count toward that $20,000 gift. And of course, charitable donations to 501c3s or approved charitable organizations do not count against that $20,000 a year. Is that clear? Next, how to transfer property by will or trust. I think we've kind of gone through that. The will, once it's validated by the courts through the executor process and everybody's announced, then the executor again has what we call a fiduciary obligation to make sure that the wishes of the will are carried out. Same thing with the trustee. The successor trustee has a fiduciary obligation to carry out the wishes of what's in that trust. Transferring property by contract. This is, first of all, is joint tenants with rights of survivorship. Does everybody understand what that term means? Okay. If you own a checking account, a savings account, a brokerage account with two owners with rights of survivorship, if one person dies, the surviving person that owns that account becomes 100% owner. So Tim and Chris Heisterkamp. Well, let's use this. Yeah, Tim and Chris Heisterkamp, we own it. One of us dies. I die, Chris owns it all outright. Let's go to the next one, tenants in common. Let's say Max and I own an account together and one of us dies. Since I'm older, I'll die first. So my share will go to my heirs. Max does not get that money if we have tenants in common. So it's very important that you know the difference between tenants with joint tenants with rights of survivorship versus tenants in common. So my share would be distributed by my will at that point. Finally, transfer on death and POD. We talked about that. This is what counts with named beneficiaries, and it goes very, very quickly. As soon as a death certificate is available, that beneficiary, if they know about it, can bring that death certificate in to us or to the bank or wherever that account is held and lay claim to those assets. That does not have to wait to go through the whole probate process, or it doesn't even have to wait for any creditors that try to go after that. And again, we said it before, contracts always trump the will. Contracts will trump the trust. Contracts rule when it comes right down to it.
Same thing.
Oh, yeah, same stuff. Yeah, it's life insurance, annuities, IRAs, retirement plans, all contract driven and all have named beneficiaries. It's really, really important to name a beneficiary. Don't just leave it blank, or don't say my estate, or I even tell people don't name a trust on these, on these types of accounts. It just muddies the water and it does not solve anything. The only way that a trust should be named as a beneficiary is that, let's say you had a special needs child and you have a special needs trust as a beneficiary. That'd be the only situation where I would name a trust as a beneficiary of an IRA. Or an annuity or a 401k, because it just muddies the water every other way. So it's only in a special needs situations that you do that. Major life changes, what you should do: death of a spouse, death of a child, divorce, being remarried. These things are all really important to step up and rename the beneficiaries. There's a legal term called persterpes that if you didn't do it, so all of my accounts that I have, like my IRA, my 401k, Chris is my primary beneficiary. My kids, Aaron, Andrea, and Philip, are my contingent or secondary beneficiaries per stirpes, which means if one of my children predeceased me, when I die, my deceased child's share goes to their kids. Got it? Say it again. That's called per stirpes. If I had set up what we call per capita, and how one of my children predeceased me, then the two remaining children split it all. And my grandkids for my deceased child gets nothing. So very, very important. We set up the vast majority of our clients that counts per stirpes. Now, if you have 3 kids, 2 of them are married with children, one of them's not married with no children, then we can set up 2 of them per stirpes, and the one that's not married, we can set up per capita. And so that person's share would go to the surviving children. So you don't, it's not you got a one size fits all, you got to put them all in there together. So divorce is really, really important to take care of that, and being remarried. So when I think about well, let's not talk about divorce. Let's talk about if I die. Let's say that I die, Chris becomes the owner of all of my accounts. What if she remarries? Well, it's her money now. She can choose to name her new husband as a beneficiary of my money if she wanted to. We try to encourage our people to think that through a little bit and make sure that money goes to the kids. Because what if I die, Chris got remarried, and then let's say that, and then she named her new husband as a beneficiary, and then she dies, he has all my money, and he could technically write out all my kids out of my money, and he could give it to his kids. So just rubbed me the wrong way, sorry, but I just say, talk these things out, make sure that everybody knows this is what's going on. I know my parents did. My father has been gone for 30 years, and he and mom, they were both inheriting farmland from their parents. And they talked about it, that if one of them got predeceased the other one, that would go straight to the kids. Now, when my father died, he predeceased my grandmother. When she died, she went to my mother and said, I am naming you in my father Glenn, in Glenn's spot. But when he died and mom got the share of their inheritance, she just turned around and gave it all to us. So I think most of it anyway, but us kids. Anyway, things to be paying attention to. Big thing to do, major life changes, is check your beneficiaries on your life insurance, annuities, IRAs, retirement plans, anything that you have a TOD or a POD, and then the per capita and per stirpes we just went through. So does anybody have any questions? If we're going to leave you with one final thought, is talk about it with your family, talk about it with your parents or your kids, but don't think that it's taboo. Don't think, well, if I talk about it, it's going to happen. I got news for you folks. It's going to happen whether you talk about it or not. So it's just a matter of when, not if. So just get these discussions going. And if you have parents, it's very, very tough for, especially if they have elderly parents to talk about it if they don't bring it up first. So my mom has been fortunate, and because she trusts me with everything, she talks this through. But I have a lot of clients whose parents are getting up there in the upper 80s and 90s, and they don't have any idea what their folks have or what they don't have or what's going on or who's the executor. And so,
and we hear people, and you probably are the people too, who take pride in not wanting their kids or sometimes even a spouse to even know where things are going. So yeah, it always simplifies things. It helps the next generation to talk about these things. So
I think it just gets very bad when you don't do that. So,
yeah,
there's a lot of confusion and heartache and disappointment. And in the end, when Chris and I are both gone, we want our kids still get together at Thanksgiving and Christmas and 4th of July and hang out together. And so we want to make sure there's no animosity between them after we're gone. So, what questions would you all have? Anything you're maybe a little bit confused on? And don't feel embarrassed like, oh, I didn't quite get that. I mean, there's not a silly question or a dumb question here.
Put Alan in happening, or you put 4. I guess I've heard that you put Ann and Alan died when they first. Then it pulpit or whatever.
Yeah.